This meeting is being recorded.
All right, we've got participants joining. Let me just check. All right, I'm going to elevate Amy. There we go. She should be joining soon. Hi, Amy. Okay. Good afternoon, everybody. Sorry for the slight delay. We had a few technical difficulties, but we're ready to start. My name is Tara Raghavan. I'm the president-elect of SABA North America, or the South Asian Bar Association of North America. And I'm happy to and delighted to introduce this panel today, or this webinar today, What's Happening in Health Information Privacy. This is not only on behalf of SABA North America's Health Law section, but is also co-sponsored by the IAPP KnowledgeNet of Northern Virginia chapter. And we're going to be discussing going on and updates in health information privacy. I'd like to hand this over to two of our co-chairs of the Health Law section, Alia Suleiman and Amy Kabaria, to take it away. Thank you, ladies.
Thanks. Alia, if you want to start, feel free.
Oh, well, you can go ahead and start, Amy, and then maybe I'll just introduce myself during introductions.
Yes, thank you both. My name is Amy Kabaria. I am an associate at Davis Wright Tremaine in the Technology, Communications, Privacy, and Security practice, focused on health information privacy. I'm very excited with Alia and the rest of the panelists to put this on today. We're giving some spotlight to health information, what's going on, what people are thinking about and excited about. And so in a minute, I'm going to turn it over to the other panelists to introduce themselves. I know you all have been waiting. Thanks for the brief wait as we sort of technical difficulties. And then we'll get right into it after everyone has a chance to go around and introduce themselves. So I'm just going to start on my left. Dean, you're on my left. Would you mind going?
Thank you very much. My name is Dean Whalen. I'm an attorney. I reside in Massachusetts, and that's where my practice was for 20 years. And then I joined the corporate world. I was a litigator, and I joined the corporate world. And I joined a company, and that's where I really had to bump into privacy and all the concerns associated with what we're going to talk about here today. The company was a web-based transcription company, so we dealt with healthcare hospitals across the country. So you can imagine the varying regulations that we had to be aware of, and that was the first step, obviously becoming aware. And that's, I think, what this panel hopes to bring to a lot of people is general awareness, first of all. And then from there, you get into the more specifics. And my state of Massachusetts has a stringent law, which we'll probably talk about a little bit later. But the world is a much smaller place, and so I expect to learn more than I'll give today, because there's a lot of great panelists here. So thank you very much.
Adam is next on my screen.
Thanks. Hello, everyone. My name is Adam Green. I'm a partner in the DC office of Davis Wright Tremaine. My focus is also health information, privacy, security, breach response, and information blocking. I've been with DWT for about 11 years. Prior to that, I actually worked over at HHS doing primarily HIPAA over there. Looking forward to joining the panel today.
Okay, after that, I have Ty Kayam.
Thanks, Amy. Hi, everyone. My name is Ty Kayam, and I'm part of the Health and Life Sciences team at Microsoft, where I have a dual function of doing tech trans and digital health space, and I support on our regulatory and policy issues at the intersection of health and technology. And I'm based in Seattle, Washington.
And then Alia, over to you.
Hey everyone, I'm Alia Suleiman. I am an in-house lawyer and sort of director of health policy and regulatory affairs for Epic, the electronic medical records software company. And I have been working on privacy in the digital health space my entire career. And at Epic, if it has a privacy, security, or data use bend to it, it often ends up on my desk. So really excited to be talking about health information privacy with these panelists today.
Great. And then just as a finishing up my introduction, I'm based in DC, if I haven't said that. I started out in health, general health industry advisory, and then recently joined DWT, and prior to this was Associate General Counsel, Chief Privacy Officer at a publicly traded professional services firm. So that's all on me. We're going to turn it over to the panelists. I think Dean's already kicked us off on this, but feel free to say more, Dean, or maybe I'll come back to you at the end. Kind of, how did you get into data privacy? And again, we've already heard a little bit, so maybe we'll be quick on this. But if anyone wants to talk about what their career path was like how did they get into data privacy? What's changed and how have they seen their career evolve as the space has evolved? I feel like we spoke about how that might give some background to the rest of the conversations we had. So, Ty, I don't know if you want to start us off on this, and then we'll go around.
Sure, happy to start off. So I started my career in the healthcare practice group of a mid-sized firm called Felsman Tucker, where I found myself gravitating toward health and tech issues. I worked on HIPAA stuff, Part 2, EHR and tech vendor contracting, R&D stuff, and I knew I loved this space. I went in-house to a health information network called SureScripts, where we, beyond just thinking about privacy, we also focused on health data use rights requirements, and along with that came interoperability, information blocking, TEFCA, the framework that we think of today when it comes to the sharing of data. And then after that, I came to Microsoft. It's been 2.5 years. And at Microsoft, again, I have a dual role of tech trans and regulatory and policy support. And I work on beyond just health privacy, along with thinking through how data use requirements and privacy intersect with AI, mixed reality, and other emerging technologies. And we have the help of Adam here and other great people to figure it all out.
Thanks. Adam, I don't know is there anything that you might add about your path to health information privacy?
I'll say it was not love at first sight. So I actually in law school did a master's in public health program also, and was doing a project that got exposed to a proposed rule called HIPAA. And it was the only thing standing between me and graduation at that point. And could barely make heads or tails of that proposed rule. And at the end thought, okay, thank God I'm never going to have to see that rule again. How little I ever imagined, but it got finalized while I was a associate at a law firm, and I found myself doing more and more of it and enjoying it more and more. And so when there was an opportunity to do HIPAA full-time over at HHS, I went ahead and took that opportunity and have never regretted it since. And so ever since, I've been strictly privacy and security.
Great. Alia and Dean, maybe we'll, I know you mentioned a little bit, maybe we'll start with Alia and then Dean, if you have anything else to add.
Yes, and hopefully my audio is a little bit better now. Yes, great, okay. So I got started in privacy really thanks to a super interesting class I took in privacy law as a 3L. And the intersection of data, technology, and ethics, frankly, was something that I had found, it just felt very rare in a law school class to be talking about all three of those things, at the frequency and at the depth that we covered in that class. And so I was really fortunate that one of my first roles right out of law school was with a clinically integrated delivery network that had a plan to acquire specialty practices and put them on standardized digital health tools, and then add on more digital health tools for patients of those practices. And so I was able to kind of witness privacy issues come to a head real time as provider organizations with sometimes overlapping and sometimes not overlapping patient populations had to make sense of using new digital tools. And as the company, which was started by a couple, co-founders with a heavy tech background, wanted to introduce more consumer-oriented technologies to patients visiting those practices that weren't necessarily HIPAA regulated. offering. So that experience set me up really well to work on health information privacy at California Statewide Health Information Exchange, then called CalIndex, now known as Manifest MedX. And there I was able to work on setting up a data use and privacy framework for health systems and health plans to use what I think at that point was certainly the state's largest database of Californians' medical records and health plan information. And so these, being able to work on those issues at scale was an eye-opening experience from a health information privacy and data use perspective, because as you can imagine, the provider organizations and plans had very different use cases and goals for their data use activities. And goals that sometimes could be supported by de-identified information, goals that sometimes really needed, fully identifiable PHI to be accomplished. And I've been really fortunate to be able to work on those issues at an international scale in-house at Epic, where we are not only developing products that aggregate, collect, and analyze data for healthcare organizations domestically, but also healthcare organizations across the world, including in the European Union. In fact, my very first day at Epic, I had a binder on my desk that had a copy of the GDPR in it, and was asked, like, hey, we really need someone to take a look at this and see if there's anything in it that we've got to be concerned about. So that was a really fun start to my 2017. So yeah, it's been a wild ride on different health information privacy issues over the last almost 8 years. But it's I feel like I say this every year, but it just feels like an incredibly exciting time to be working in this space. There's so much changing. There's so many ideas on how things could change that have yet to come to fruition. So really excited to kind of dive into the details. And Dean, I'll pass it over to you.
Yeah, so if I'm keeping it real, not only was it not love at first sight, it's really, I'm forced to do this more transactionally as part of my job. And I like to keep folks like you on retainer for the heavy lifting. And one of the things that, in addition to obviously all of the concerns associated with doing the transactional stuff, I was the point person on creating or implementing the SOC 2 certification of our company. And so understanding all the controls of how you actually implement controls associated with all of the concerns of privacy, I had to learn. And I also am kind of really concerned about the health industry, in the sense that I'm the chairman of a board of a hospital. And when you ask some of the questions associated with privacy, some of the answers you get as a governing body are disturbing. So these are really, really important topics and things that we have to really push to the business leaders, that they should be focusing on this stuff.
Yeah, great points. So, I think since we have some a few different really interesting topics to talk about, maybe we'll come back to hearing more about your day-to-day lives and sort of more about each panelist personally at the end. And I thought maybe we could get right into the discussion and start talking about what health information privacy issues are you thinking a lot about these days? You've all alluded to them a little bit. We've heard a little bit about international health data issues. We just heard a little bit about security, but if we could just kind of go around and hear about what you're talking about, follow up on those. And then for those who are watching, just wanted to let you know that we'll try to do questions. If you have questions, you can save them for the last 10 minutes. We can try to turn to those. Then if you want to go ahead and put them in the chat box, we'll just take note of them and come back to those later. So Adam, what's on your mind these days, health information privacy wise?
So I think some of the interesting developments of late, the FTC came out with what they called a clarification or a policy statement in last September. And I think it's one of the more interesting health information privacy developments of late, because essentially the FTC has always had broad authority with respect to for-profit entities, with respect to prohibiting unfair and deceptive trade practices, and it's used that as a really as its hook for privacy and security, but it's got significant limitations in that area. I mean, it really has limits on the ability to impose penalties. It has limits on the ability to put forth kind of clear standards. But then you had this other statutory authority dating back to the HITECH Act in 2009 for personal health records. And back in 2009, personal health records, I mean, there were a few vendors with kind of some new products out at the time. And I think everyone had a conception back in 2009 of what a personal health record really was. It was kind of the idea of a digital filing cabinet where you can stick all your medical records and have them there stored on your behalf. And we haven't really heard much about this breach notification rule for personal health records since 2009. There's never been an action brought under that rule, but there's certainly been growing interest in the area of kind of consumer health apps and that are outside of HIPAA. And so we got this policy statement last year, which essentially said, oh, we're just reminding everyone that we have this rule regarding personal health records, which, by the way, encompasses essentially any health and wellness app where data is brought in from multiple sources, like your phone's calendar, and also maybe is input personally by the user. And they essentially redefine personal health record to just encompass practically any health and wellness app and bring it under this breach notification rule. And from my perspective, it's left entities in a really interesting spot. I don't want to go into all the technical details, but I think there's a fairly good argument that the FTC has exceeded its statutory authority here, that it's gone beyond the definition of what is a personal health record. But people are not necessarily lining up to challenge them on that. And so entities in this health and wellness app space have to decide whether they want to just kind of accept this policy statement by the FTC, and treat their apps as falling under this rule, or whether they would want to fight it either now or some later day if they ever have a breach. So, that's one that I think is particularly interesting of late.
That's great. Kai, what about you? What are you thinking a lot about these days?
There's a lot going on these days. To add to what Adam's saying, I think, in parallel, we have the Flow Health settlement that came out. There's also the information blocking trackability rules, where it's now, becoming clear that information needs to be shared to a lot of consumer health companies without, say, some of the review that HIPAA requires. Where as a covered entity or business associate, your involvement is to inform them of potential risks, not necessarily the risk of the specific company, or you don't necessarily have the ability to vet the company. And so how do you sort of marry these two requirements of having more information sharing requirements along with the privacy infrastructure that we live in today? And one thing that keeps me up at night is the fact that a lot of these laws were written a long time ago, and they haven't necessarily worked with or contemplated the technology that the way it's evolved, and particularly during the pandemic, it's evolved very rapidly. And so it's applying these older laws to modern technology and operationalizing it. I think that is fairly difficult. The other big thing that I know is top of mind for Alia as well is how the European Union is thinking of health data. And and the rule specifically relates to the European health data space. And it's interesting. It's like a patient rights light version, along with requirements for EHRs and requirements for primary and secondary uses of data, with an overlay of data localization. So it's very interesting to sort of figure out how that's going to work with the system we have in the United States. I know that Alia is that probably keeps her up at night as well.
Yeah, sounds like a national progression, national transition to Alia. Alia, do you have thoughts on that?
Yeah, Ty's absolutely right that I think there's a lot happening in Europe right now that has major implications for not just developers of electronic health record systems, but all sorts of digital health tools that are used to manage what the EU currently proposes to define very broadly, as sort of individuals' health information. And I think one of the wrinkles that we often think about from on the ethics side is, how do we harmonize requirements across different jurisdictions so that we're ending up with a world where folks are generally required to use mature, widely adopted standards to communicate health information, and where folks have where patients and consumers have some level of transparency or as clear of an expectation as possible about how their health information might be used. And I think what you're seeing with the policy statement from the FTC, recent FTC settlements, and just overall signaling around, hey, we know health information is moving outside sort of the traditional HIPAA regulated space, and we're paying attention. I think it's kind of a recognition that we've got these interoperability rules that came into effect a little over a year ago and really changed the landscape of health information exchange incredibly. I know that from an Epic perspective, we track the number of API calls that our healthcare organizations respond to per month. And it is shot up from sort of the millions to billions since these interoperability rules went into place. And what we're seeing is increased engagement from kind of what I would call sort of a super user set of patients that are really interested in managing their health information through different consumer-oriented apps and technologies. And I think the industry has yet to see either our regulators or even some private sector bodies do what I would consider a regulatory impact analysis on how this increased flow of health information is impacting individuals' privacy, and what maybe, sort of what expectations are being missed, or what are being, which are being met when it comes to how this information is being handled, protected, and redisclosed after it's moved out of that traditional kind of that white picket fence of HIPAA, where there's at least some clarity on baseline privacy and security protections as well as purposes of use. So at Epic, we think a lot about what you sort of raising as much transparency to consumers and patients as possible when our technology is being used to facilitate that exchange. But as Ty mentioned, there's only so much we can do under the domestic interoperability, kind of regulatory framework. We can put forward a million different surveys to apps to fill out to provide transparency into their data handling practices, how they protect data. But if an app chooses not to fill that out, then all we can tell a patient is they didn't fill it out, but proceed with caution. And I'd say from a personal level, sometimes it feels it feels a little disappointing to put patients and consumers in sort of like a buyer beware scenario where the responsibility is on them to make informed decisions about data sharing and how their information is shared with very little, knowledge to really make an informed decision. So we're paying really close attention to kind of, what the articles about health information privacy issues and challenges. We're paying really close attention to state laws that are cropping up that may provide consumers with additional rights and privileges when it comes to the data. And then, of course, the ever elusive, comprehensive consumer privacy legislation at the federal level, is something that we keep talking to folks about, and it's not seeming super likely, at least in this Congress, but certainly would fill a big gap when it comes to creating consistency for patients and consumers when it comes to the use of their health information.
Oh, sounds great. With the mention of state law, Dean, I know you probably have a good amount of awareness around Massachusetts, and Massachusetts has had some data privacy protections, even if not a comprehensive data privacy law for a while. So I'm just kicking it over to you if you want to start on that or anything else.
Yeah, I think we touched on it, but just the general, nothing's uniform across the United States as far as these laws are concerned, and they are starting to pop up. If you start in California, we all know California can be very regulatory, and certainly that law is interesting. And, you know, as a business to business, we're dealing with hospitals in California, Massachusetts, et cetera, et cetera. So first of all, you need to be aware of these different data privacy laws. You know, and in Massachusetts in particular, while it was 2010 when they instituted this, they were a bit ahead of the curve. They actually had some requirements in there that the business leaders and attorneys really weren't grappling with, and requiring, for instance, a written information security plan with anybody who had Massachusetts residents' health information. So you could be a vendor in a different state and actually be subject to the Massachusetts regulation. So things like that. There's a lot of tripwires in these that as an attorney, as in-house counsel, you want to be aware of, but you also want to make sure your vendors are aware of them. So I'm interested in the other panelists' ideas on how do we wrap our arms around how all these moving parts with the states.
Yeah, maybe we jump ahead to this question. And so one of the items that we wanted to talk about was what's on the horizon, and clearly it's the passing state data privacy laws. Adam, I know you know, is this something that, what are your thoughts on this?
I mean, it's definitely a challenge. I mean, there's the, you know, perpetual unicorn of trying to create forms and processes that will comply across all states. And you're never going to be perfect. You can do your best. And it, you know, always creates kind of a, I don't know, highest common denominator sort of situation where you're, you know, one state suddenly is stricter in one area and you're adopting that on a national level. So, you know, I think that's been one challenge, you know, looking at the intricacies of how these state laws interact with health information. So for example, one state law may exempt protected health information, but only in the hands of a covered entity or business associate. Another state law, like Utah, for example, seems to exempt all protected health information, regardless of whose hands it's in, and seems to also exempt all covered entities and business associates, regardless, not even limited to PHI. And so those distinctions can actually have really big differences with respect to, for example, does this state law apply to my employees? Do I need to create an employee privacy program if I'm a hospital, for example? You know, some of these state laws, most of them exempt nonprofits, but not all of them do. And so trying to stay up with, you know, those really technical details that could actually have a significant operational impact, I know has been a big challenge for clients.
Yeah, Ty and Alia, are you dealing with this right now? Is this something that people are going to revisit at the end of the year? How's this topic for you?
Alia, do you want to start?
Sure, yeah, I'm happy to get started. So I think absolutely, this is kind of top of mind. I think as you know, anyone who works for an organization with, you know, kind of a broad base of, you know, domestic operations has got to be paying attention to this. And in some cases, if you recruit from some of these states on sort of an employment basis, you might need to pay attention to this. I think now that we have 5 states that have enacted their own state privacy laws, California, Virginia, Colorado, Connecticut, Utah, and you've got effective dates scattered across the next few years, and you even have amendments starting to proliferate to some of these laws, it's a really complicated time for anyone that is offering products, services, or dealing with this regulated information. And then, of course, you know, what's regulated information? You know, Adam just mentioned some interesting exemptions that I agree, Adam. When I read the Utah exemption, I was like, did they mean to do that? But you know, you've got the CCPA, which has its in California, which has its own definition. But then you've got 4 states that are borrowing a lot of terms and definitions from the GDPR. So, you know, for you folks that have had to pay attention to the GDPR over the last few years, you know, yay for us. We're getting a little bit of a reprieve when it comes to learning new terms. But I think the challenge ahead for organizations with the broad base of operations is deciding, do you just kind of pick the highest bar and build a compliance and privacy program, to that standard? And what are you sacrificing from a data utility and usability perspective to do that? I think that, California and CCPA plus like CPRA was one thing, but now as we see more and more states advancing these bills, it's going to get much harder to take a state-by-state approach and have, a Virginia privacy notice and a Colorado privacy notice and, so on and so forth on, on your websites, facing applicants. And so I think that we're going to get to a stage where folks are just sort of deciding what the kind of highest bar is. I don't want to use lowest denominator here because I think it really is like, you've got to comply with the highest, most stringent requirements. And then hopefully have that flow through to support your compliance with other rules. But one of the I'd say overall questions that I receive all the time from our software engineers and product developers at Epic is like, how do we, as we're developing new tools and services, how do we future-proof them? And especially when these tools and services might be focused on recruiting or marketing to prospective patients whose data isn't actually PHI yet. It might be, and kind of how do you bridge the gap between these consumer privacy laws and HIPAA when data sort of has a different regulatory status for one period of time versus another. And I think that it's a big challenge, and I think we'll have real limiting impacts, unfortunately, on developers, level of comfort to kind of innovate in the patient CRM sort of space, because the lines of when do you move from one regulated paradigm to another are pretty blurry.
Thanks for that, Dean. Do you have an approach to sort of this patchwork of state laws? Is there anything that you are thinking about doing, or that you might, worth a suggestion?
My CEO never likes it, but it is all about picking the major areas and using the most stringent test for each piece that you need. And if you comply with the most stringent piece in one state, it's certainly going to comply with a less stringent piece in the other state. So I think I've heard that advice a couple times from the panelists. I agree with it. Where you haven't complied to maybe that level in a state that you don't need to, you don't have to reinvent the wheel until you have to. But I think that's the approach I take.
Makes sense. So there's another topic that's pretty big, and that's on the horizon, and that's changes to HIPAA. So Adam, I'm gonna turn this over to you and see if there are any thoughts on that.
Sure. So yeah, I think, what's interesting with HIPAA is what's being proposed with respect to changes, and oftentimes what's not being proposed yet, and questions around that. So for example, we've got a proposed rule that was published on January 21st of 2021 and expected to be finalized later this year or next year. And you've got a proposed proposal to change the right of access, for example, from 30 days plus a 30-day extension available to 15 days plus a 15-day extension available. Changes with respect to things like minimum necessary and care coordination, and some things that already were out there in guidance, but that would be put into the regulation itself, like the fact that providers can share with social services agencies and other non-healthcare providers, that sort of thing. So you've got some of those things that have been proposed. There's other areas, though, that we didn't see proposed in the rule. So, for example, accounting of disclosures, the can continues to get kicked. I don't know that anyone's particularly complaining about not getting new accounting disclosures regulations, but that seems to continue to be a challenge. And then we had the MD Anderson court decision had, a number of significant things, including questions about what the appropriate penalties are under HIPAA and what the definition of disclosure really is, things like that. And we haven't seen that addressed in the proposed regulations. So we continue to have ambiguity there. So, we're in a very interesting time of flux with respect to HIPAA, with a number of proposed changes now, but a number of ambiguities popping up due to things like court decisions.
Adam, could I ask your opinion on the fate of minimum necessary under HIPAA? Because when you talk about ambiguities under HIPAA, I think that is one of those provisions that, especially in the context of the interoperability rules, like Ty first mentioned, it's sort of like where permitted, you're now required to share under the interoperability rule framework, yet you have this, kind of flexibly worded, I would say, provision in HIPAA that requires regulated entities to use, reasonable measures to kind of, use the minimum necessary health information. But to me, when I read the HIPAA RFIs, especially around healthcare operations and care coordination use cases, it seems like they were kind of moving away from that as a concept. But I'm curious what you think.
I think minimum necessary is something that works in concept, but then in practice is fundamentally broken. So you have in the regulations these requirements for protocols that I will just say I'd be interested to know how many entities out there have the level of protocols, minimum necessary protocols that are called for in the regulations. But while the theory of you should only disclose what's the minimum necessary makes complete sense, I think health information exchange in an electronic environment, it just doesn't work, because the reality is in an electronic environment, you either provide access to a specific type of data set like a CCDA, or you provide full access, like here you have access to the entire EMR record, but there doesn't really seem to be a way to comply with minimum necessary in an electronic environment. If I'm a health plan and I want to check whether someone really should have gotten that power wheelchair rather than a manual one, there's not a way for me to get electronic access to the record and only see that which is relevant, and not the STD from 20 years ago that might be completely irrelevant. So I think it was interesting in the proposed rule that they proposed a care coordination exception for minimum necessary, which is great, but they haven't, in my mind, addressed the really big minimum necessary issues, which is just that it doesn't work in an electronic health information environment.
That makes sense. Ties. How are you thinking about the proposed changes to HIPAA? Is that coming up for you?
It's coming up, but beyond that, I think on the topic of elusive laws, it's part 2 as well as top of mind. I think we're all waiting with bated breath to see how it aligns or doesn't align with HIPAA and how various organizations should think about it. I think we've sort of blown past the date where we're expecting to see something, so it's just a waiting game for that. A couple of other things that are top of mind for me is how we are thinking about health equity within data and privacy issues. We're seeing several agencies come out with guidances, whether it's CMS, the FDA as it relates to clinical trials, and I think ONC is now looking at bias and algorithms as well, and how it interrelates to privacy and data. I don't think there's a concrete structure on how the concept of health equity will sort of work within data use or health privacy, but I feel like we're at the starting line, and hopefully it's thought about more, incorporated more as well. I think AI is also very, how AI works with HIPAA with various other state, federal, international regulations. I think that's still unclear. We're seeing the AI Act at the EU phase. We're seeing various task forces within the government opine on it, but again, very early stages of regulation. Even in Canada, it's a proposed rule. No one's I think, gotten it right, so much so that it's final law just yet, but a lot of proposals out there, including as part of the FDA. So that's something that I'm also thinking about quite a bit.
Yeah, I think the AI, you brought up about AI might be something for us to come back to. And I want to come back to that. But first, Dean, do you have any thoughts on the proposed changes to HIPAA?
No, I've heard a lot of good things though and learned some things. Thank you.
Yeah, sure. Adam, what about AI and HIPAA and data privacy? What comes to mind for you?
Oh, so yeah, there's I think a lot of challenges out there as to AI development and where does that really fit in. So, for example, if I'm a customer of AI and I purchased version 1.0, does the developer get to use my data to develop version 1.1? Is that kind of part of the service, that sort of development? I think that's an open question. I at the IAPP Global Summit kind of opened that up to the audience, and it was fairly well split, with a lot of people taking the view, oh yeah, that's fine, that's kind of part of the delivering the service, and other people going, oh, absolutely not, that's kind of developing new products and services, and that's not allowed. So I think there's a lot of ambiguity out there as to where, can I develop AI as part of delivering the fundamental service I was contracted for? I know there are some out there who even view it potentially as part of proper management and administration. Is it potentially research? If you talk to an academic medical center as to what qualifies as research, I think they're oftentimes thinking, well, it's going to get published in the New England Journal of Medicine or something like that, versus, commercial R&D. The R does stand for research, and you do have kind of commercial researchers, and if you talk to kind of a pharmaceutical company, they have a very different perception of what qualifies as research. And I think trying to figure out where AI development falls within that, is that part of research, which isn't a get out of jail free card. You still have to comply with certain requirements like a institutional review board waiver of authorization, but I think people are really struggling with how kind of AI development fits within these frameworks that were clearly not developed decades ago with AI in mind.
And I would maybe add, in the area of clinical AI, you also have the FDA considerations of, is it a medical device, or do you need to cross off as medical device requirements? And are there, free market submissions that may be required? I think that's also another overlay when it comes to AI as well.
Yeah, one thing I would just add is that I think, Adam, you sort of hit the nail on the head, that from a kind of a privacy and data use counseling perspective, one of the key challenges is understanding the data that might be necessary to develop a particular product or service, or in this case, an AI or machine learning based tool. And then trying to figure out what are our rights to use that data for that particular purpose. And I think that, sort of a healthcare operations, proper management and administration kind of label is workable for some organizations. I've seen other organizations really balk at that and take an approach where that, really classified that data use activity, to develop a, say, like a predictive risk score for something as more of a research activity. And then, you've got this question, well, capital R research is supposed to contribute to generalizable knowledge. And if you are developing a tool that's for a very specific set of patients, and maybe only patients seen at a particular organization, maybe if in the case of a health IT developer, are you developing a tool that will only be available to a subset of your customers in a particular market area? Are you contributing to generalizable knowledge? And I think that if you look at this is a case where you've got a definition for capital R research that has a lot of elements under the common rule that are similar to its sort of definitional elements under HIPAA. And you are, I think you could do a quick Google search of academic medical research institutions and see wildly different interpretations of what constitutes something that contributes to generalizable knowledge. And beyond a handful of kind of, somewhat vague preamble discussion about that concept, somewhat vague sub-regulatory guidance on that concept, there isn't any sort of definitive checklist of if you do these things and publish in the New England Journal of Medicine, like you're definitely contributing to generalizable knowledge. So I think as as counsel out there, we have quite a task ahead of us to sort of listen to folks who want to engage in these novel data uses, really understand the underlying drive behind developing and launching a product, who it's intended for, how it's intended to be used, to be able to provide a like sort of fair assessment on whether this thing really does feel like research, or maybe is something that it necessitates a special type of data use agreement or other arrangement to facilitate that particular use case.
Adam, do you have any responses to this?
Well, and I'll just throw out, there's the legal question, and as outside counsel, I tend to focus on that, but there's always the reminder of, and even if you have a legal basis to do this, are you fully comfortable with it ending up on the front page of the Wall Street Journal, for example?
Yes, a court of public opinion along with the courts themselves.
Makes sense. So we have 10 minutes left. So I wanted just to ask if anyone has questions, please feel free to chat them, and we can start reading them out. And as we see those, we can stop and answer them. In the meantime, I can continue this discussion and say, so on this topic, what's come up a few different times is we're kind of at an exciting time. There's a lot happening, both on what's going on with laws passing, as well as we're seeing technologies develop and become adopted, and the use of them is growing. So are there any other areas? We're talking about AI right now. Are there any other areas that people are looking at and saying, there's just a lot of interesting questions because of this sort of regulatory uncertainty, or it's because the laws and technology are intersecting in interesting ways?
I had a question. How are places like Epic and other entities that we know about, how are they dealing with the opt-out provision of these laws where people opt out? Are we seeing a translation perhaps from that signed document through the chart and ultimately where it needs to go? I mean, how are you grappling with that?
Yeah, I'd say approaches vary. I know there are some organizations that have wanted to take a kind of a fully digital approach to capturing sort of opt-outs and presenting notices of privacy practices to individuals. But for to Kai's point about equity, for a low to no tech population, that's simply not going to be sufficient, and certainly won't be a reliable way to get an informed decision from a patient. So I think a hybrid set of approaches is going to continue to be the norm here. But I'd say, as a general matter, creating the technical mechanisms to effectuate someone's decision to say, I don't want my data included in this particular activity or study, or I don't want to be marketed to in this particular way by my healthcare provider. That is, I consider a core part of privacy by design, development in the digital health space.
Anyone else? We did get a question about, and if you can't see it or you're just listening, on the whether anyone has written a common denominator for U.S. state laws. And it looks like Alia has answered this in the chat, mentioning that the Uniform Law Commission released the Uniform Personal Data Protection Act last year. So we have this one question while we wait for any other questions. So maybe we circle back on the day-to-day, unless anyone has any other topics to add, in which case, please feel free. Otherwise, we jumped over what's your day-to-day like to kind of get to some of the substantive topics, but maybe we can go around and start. And Ty, I don't know if you want to kick that off.
Sure. No day is the same as the other. Everything's just new and exciting and oftentimes confusing. It can range from, working with customers, and Microsoft has a big cloud computing presence. So a lot of times my day is thinking through privacy and security as a shared responsibility model, thinking through things like data encryption. How do we make sure that that sort of occurs in a joint way, both from a legal, contractual, and a technical perspective, working with our various technical teams? There are oftentimes a lot of ad hoc privacy questions and data use questions that come up. The EU Health Data Space Proposed Rule that's taking up a lot of time these days. And really, we have numerous health customers that are very interested in doing a lot of innovative, exciting things. And it's thinking through how do we sort of align it with the regulatory structure that we have today, working in tandem with counsel for the customer as well. And yeah, just making sure we are good stewards of data and the trust that our customers have put in us. So no day is the same. It's a lot of emails, though, a lot of emails and Teams messages.
Yep, sure. Sorry to pause this, but we did get a question, and it's touching on the themes that have come up during this hour. And so the question asks, how will you help organizations navigate distinct requirements for health information and privacy laws? And this is versus other laws that impact the processing of health information in a particular jurisdiction, such as employment laws. Adam, I don't know if you have any thoughts on this or anybody else wants to jump in.
So I'll leave the international to others, because once it goes international, I tend to bring in a colleague. But on the domestic front, I think one of the biggest challenges has definitely been, this is not a metamorphosis where you clearly have the caterpillar here and the butterfly here. I mean, you take data on a website, for example, it's very unclear what stage it's at any given point. Is it protected health information yet that's now subject to HIPAA, or is it personal information that's subject to state privacy laws? And so operationally, I think organizations are trying to come up with, okay, what do we think is the appropriate legal position that also takes into account our business needs? Like, should we be treating all website data as PHI? Can we do so? Should we be treating it as personal information under state law? Are there situations where we want to treat it as both, even though under the different laws, you're technically one or the other? So, we're seeing challenges like that. COVID really brought the employment law questions into a whole new framework with respect to health information. So, I suddenly found myself talking about the Americans with Disabilities Act a whole lot more than in the past, based on, COVID information and vaccination information. And you've got laws like the California Confidentiality of Medical Information Act, which actually has provisions that govern both patients and then separate provisions governing employees. And so bring all that together. And so, operationally, it's a lot of times, where can we draw clear lines, and where do we just want to, where do we think the lines are fuzzy and we just want to err on the side of maybe, a document that complies with multiple frameworks?
Yeah, we got one more question. So to change topics and go back to something we've discussed, Alia, there's a question for you. How do developers in your organization ensure privacy by design? How does the NIST framework fit into your processes?
Yeah, no, great question. I think that the NIST framework is certainly informative for how to manage privacy risk. I'd say that the privacy by design principles that EPIC really prioritizes are grounded in, I think, a couple kind of very baseline principles that translate into all sorts of functionality, descriptions of practices to end users, et cetera. And that's really like autonomy and transparency. So, and it really should go transparency and autonomy, because transparency is really key to making sure that folks can exercise their autonomy in meaningful ways. And so how that manifests in our design process is that at all stages of the product development lifecycle, when there are projects that require the use of data, aggregation, collection, analysis of data to sort of inform design or development, when developing functionality that moves or curates information for particular workflows or use cases, there are questions asked about, how do we surface what's happening to this information? as transparently as possible, not just to patients, but sometimes to end users at organizations. So they know exactly what they're doing by clicking, run report on a particular set of criteria within their system. And then I'd say that in the electronic medical record kind of space, you get a lot of practice with privacy by design because there are layered and myriad consent requirements, access and use requirements. Ty mentioned 42 CFR Part 2, which treats a whole set of substance use treatment data in a very special way that requires, even within a healthcare organization, that only certain users access and touch that information for a particular set of purposes. So I think there's kind of a benefit that, sort of being in this highly regulated environment with these layered consent expectations, access expectations, has sort of had to manifest in technical controls and really a design and development mindset that thinks about, how do we stay true to these rules that, really are meant to facilitate particular uses of health information, and also maintain transparency to individuals about how their information is being used. I think on the there's so much that happens within the healthcare environment that patients maybe just don't fully appreciate just sort of it is happening because HIPAA says a whole range of things is okay without affirmative consent and authorization. So I think another kind of key aspect of sort of our privacy by design approach is to make sure that we produce documentation explaining our design decisions that healthcare organizations can take and use when explaining, a particular program or research platform to patients, so that patients aren't feeling like duped or hoodwinked, that their information was used in a way that they didn't anticipate, and instead are kind of, providers are equipped with as much context as we can reasonably provide so that they can share those explanations and work kind of the intended scope of use into their notice of privacy practices or other policies as appropriate.
Yeah, so we are at 6 o'clock right now on the dot. I think we can stop there. I feel like this conversation could go on. I heard 42 CFR Part 2, and I know Adam might have some thoughts on that, but why don't we stop here if you have questions. So Ollie and I are, for those who are here from SABA, we are your health law co-chairs. We can direct these questions to panelists, and we can also talk about getting contact information out if needed and desired, and the panelists are okay with that. So I'll turn this over. I don't know if anyone else wants to have any last words.
You're all welcome to have some last words. If not, thanks everyone for joining our webinar today on what's new and what's up in health law privacy. So thank you so much. Appreciate the efforts of the Health Law Committee or this health law section of SABA, Alia and Amy in particular, and our wonderful panelists, Dean, Adam, and Ty, as well as Alia and Amy. Great job moderating. Thanks on behalf of SABA North America and our co-sponsor. We appreciate all of you for being here and look forward to the second half of this panel so that we can learn more about this issue. I don't think we even cut the surface a bit. So there's a lot more to talk about. We look forward to having you on a follow-up soon. Thanks, everyone, and have a good evening. Bye.
Having us.
Everyone.